justified, and in Idaho, it's the same burden to rebut, to basically prove that it wasn't justified. And this is a critical element of what the state will do, establish that they're independent, the defendant, person, is not contracted to, is not provided any authority on behalf of the organizing event or the school district to remove anybody of his own accord. So that's the affirmative defense, which asserts if he was directed by the sheriff, he was commanded, he was justified in what he did. But the question becomes if he wasn't commanded, which is going to be what the state is going to argue, or it's going to argue, maybe it'll show that it wasn't in fact commanded in most instances. What then? What authority did he have? And this is going to establish with the jury that members will come up with a mind who actually have authority to remove people in this circumstance. This will provide the clarity as well.
Thank you, Mr. Hunter. I agree with Mr. Hunter in the sense that may have put the cart before the horse a bit and assuming the affirmative defenses without first allowing the state to put on whatever evidence it believes is appropriate and relevant in its case in chief. And that's where we are. Certainly any further evidence as it relates specifically to those duties of the sheriff and whether the sheriff's conduct here falls within the realm of those statutory duties is one that will be presented to the jury, and I don't think the jury can have any trouble differentiating the duties of the sheriff versus a school policy, and certainly counsel can argue that as well. And so for those reasons, I can find that area of inquiry is relevant and would overrule the objection. In terms of Exhibit 2, Mr. Hanners, did you wish to make any further argument on Exhibit 2? There was a hearsay and relevance objection.
And apologies to which
So that is the facility use agreement.
yes, right. Everything on there is hearsay and it's simply not relevant to one another. He has testimony already stating that the individual on behalf of KCRCC reached out and reserved the school. There's been further testimony that all those things took place and that the event was actually held on that date. So I just don't see the relevance to that document as well as everything in there. Hearsay. So I don't see another reason to use.
Thank you. Any response, Mr. Hunter?
Thank you, Judge. So as far as the hearsay assertion, I'm sure it's an application. As far as it's a document that contains information from the school or on behalf of the school, and there's certain questions as to whether it's a statement of consideration. But even if it is, I think it falls within the same subsection of 902, specifically subsection 5, that deals with official publications. This is something that the witness, which Stuart testified was part of the process that he had to go through the school district itself, filling out the application, to observe the venue. And so I think it's all within public publication, public publication, according to the issue by public authority. I think that's what that document would be. The completed version is authenticated as the same one we submitted, and it's relevant to establishing what the nature of the event was. Assertions that it was a private event, or certainly sounds like there's still some argument that organizers and sponsors were able to dictate and stand good. So I think this provides through information relevant to that decision, to that assertion when it comes to defendant's conduct for the charges he faces. And I think it 902.5 gets along in terms of self-authenticating, or hearsay because the document is self-authenticating that cites as a hearsay issue. So having self-authenticated documents as a means of getting the information for the jury.
So 902.5.
Yes, official publications. And I recognize that with the court's implication, the skepticism and that, but I think it's also been in other publications. It's published as this is how you apply this facility. I don't know how else to get it into these policies to circumvent or to address potential hearsay. And I think that's exactly what this was created to address. This is what is publicly put on websites, is publicly provided, or anybody who wants to use the facilities. It's what they want to fill out. So I think it counts as publication. This is the thing that you want to preserve. This is what you must fill out to use. So where it's coming from, a public authority doesn't have any concern with reliability, with veracity that normal hearsay does. And that's the whole point of the hearsay rules, is concerned with the truth of what's being said, whether it's an accurate statement of the declarant. This is a public agency, published document. It's filled out by whoever wishes to preserve venue for public use. That it falls within the scope of other publication or would be issued by a public court. Certainly this, it's a simple rule, and I think this falls within, and the remainder is a verified foundation which always issued itself.
Well, I don't think this is a self-authenticated doc, I mean, a lease agreement or an agreement like this, where there's information that's filled out by a third party, does not qualify as an official publication that somehow is on, similar or akin to a book or pamphlet or other publication put out by that agency. I think what the rule contemplates is a situation where you have a manual or some kind of publication online by that agency, and that is what's sought to be admitted. That is self-authenticating. I think here, in terms of, and I'm not getting an objection as to, Judge, this is not what it purports to be, a lease agreement or a facility use agreement. It would appear to me that if there is hearsay in this document, that hearsay is essentially records or statements relating to interests of property. And so would be admissible for that purpose. So specifically under 803, sub 14, or sub 15. Unless at some point in the future, there's some testimony that the contents of this document are inconsistent with the truth, statement or purpose of the document. And I think that the foundation was laid by Mr. Stewart in terms of this agreement and the signing of this agreement. Any further argument you wish to make on that, Mr. Hanna? If the two would be admitted, do we need to address anything before we bring our jury back in, Mr. Hunter?
No, Your Honor, unless the court would like to address that. I don't see this decision by the states post 11, 12, 13 now, or just address that when it comes up.
And that's just simply the school policy.
That's it.
That's on their website or on.
Copies directly from us.
And as I understand Mr. Hanner's objection, it was a relevancy objection. And I've addressed the relevancy objection. Mr. Hanner's, was there going to be an objection as to the authenticity of this policy?
No, Your Honor.
And I apologize to the parties, I'm suffering with a little bit of a cold, so it's a little froggy. All right, with that then, exhibit 2 will be admitted. Anything else to address before we bring our jurors back in? Mr. Hunter?
No.
And Mr. Hanner?
No.
Oh,
Judge, may I approach just real quick?
please, please. That's perfect. Move the table, record. Sure, sure. All right, I'm gonna step off the bench, stay seated, and we'll be right back.